Cher recently won quite a big victory in a lawsuit over whether a copyright termination in various Sonny Bono compositions could terminate her share of music royalties that were accorded to her in the divorce settlement between her and Sonny. I'm Scott Herbie from Weintraub Tobin, and I'm joined by frequent briefing contributor Jamie Linsenberg. We are going to talk about this case on today's episode of The Briefing. Jamie, welcome back to The Briefing.
Thanks for having me, Scott.
So let's jump into the facts of this case. So in 2016, Mary Bono, that's Sonny Bono's widow, issued a notice of copyright termination under Section 203 of the Copyright Act to various music publishers that held rights in Sonny Bono's compositions. Under Section 203, authors or their successors may terminate copyright assignments and licenses that were made on or after January 1st, 1978. Upon termination, all rights in the work that were covered by the grant revert to the author. However, any derivative works that were prepared under the authority of the grant before its termination may continue to be utilized under the terms of the grant after that grant is terminated. So apparently, though, in September 2021, Mary Bono notified Cher that pursuant to the copyright termination and their rights, Cher was no longer entitled to her 50% in royalties she was accorded under the divorce settlement agreement. Cher ended up suing for declaratory relief to enforce her rights under the marital settlement agreement she had with Sonny Bono.
And there is some important language in the marital settlement agreement. So let's highlight that first. The agreement, which is governed by California law, gave Cher a 50% interest in any record royalties, which is all contingent receipts payable after July 14th, 1978, from Atlantic Recording Corporation under the agreement dated August 30th, 1966. From Liberty UA Inc. under the agreements dated from and after November 1st, 1964, and from MCA Records Inc. under agreements dated January 1st, 1972 and February 11th, 1971. It also gave Cher a 50% interest in any composition royalties, which is the contingent receipts payable after July 14th, 1978, from musical compositions and interest therein written and composed in whole or in part by Sonny or others prior to February 1st, 1974, and or acquired by Sonny and certain other entities prior to the couple's separation.
That's right, Jamie. The marital settlement agreement also states that any of Sonny's successors in interest or assigns are also subject to Cher's rights in both the record royalties and the composition royalties. So in Cher's lawsuit for declaratory relief, she sought from the court a declaration that Mary Bono's copyright termination notice did not terminate and could not have terminated the marital settlement agreement and its assignment to Cher of 50% of the composition royalties. Mary Bono took the position that Section 304C of the Copyright Act, the copyright termination section, preempts state contract law as to the rights to the renewal terms of the copyrights at issue. And as a result, the marital settlement agreement is now preempted and lacks effect.
The key question before the court was whether the composition royalties and certain approval rights under the marital settlement agreement constitute copyright grants that were affected by the notice of termination.
Right. Now, the court did find that the marital settlement agreement is linked to the musical compositions and Sonny's corresponding property interests. However, the granting of a royalty and the approval rights that are within the marital settlement agreement did not refer to and were not a grant of a transfer or license of the underlying copyrights, and Cher's rights under the marital settlement agreement arise solely under state law. Section 304C of the Copyright Act expressly provides that it in no way affects rights arising under any other federal, state, or foreign law. And as such, the notice of termination issued by Mary Bono cannot affect Cher's contractual rights to receive financial compensation as was set forth in the marital settlement agreement.
Right. And this does align with the holdings of other courts, finding that a right to receive royalties is distinct from a grant of copyright.
Yeah, that's right. I think this case is a good reminder for those of us that may be involved in a dispute that involves copyright assets. So clearly, in any marital settlement agreement, when the community property involves copyright interest, it's probably not the best course of action to transfer any interest in the copyright. But I mean, this also goes beyond the marital settlement situation and can include any type of settlement situation.
Yeah, that's interesting and definitely a good reminder.
Yeah. Well, Jamie, thanks for joining us today.
Thank you for listening to this episode of The Briefing. We hope you enjoyed the episode. If you did, please remember to subscribe, leave us a review, and do share this episode with your friends and colleagues. And if you have any questions about any of the topics that we covered today, please leave us a comment.